Legally Speaking show is here once again. Welcome on board. Hope you've been fine since the last time we met. As usual, we are here to educate you. We are here to create awareness and make sure that you fully understand what law entails and how it is related with our day-to-day activity. Welcome on board. As I've told you, 22914 Facebook page, Mwangaza TV, and YouTube channel Mwangaza TV. Of course, I'm your host, Celestine Waka the Favored, and today I'm joined by Dedan Chege, who is an advocate of the High Court of Kenya. He has been practicing with so much passion in criminal law for over 6 years, and today he is going to take us through. You want to know the difference between civil and criminal law? This is the place. You want to know why one person goes in for 20 years while the other one is given a life sentence? Today we are here to make sure that we are giving answers to each and every question that you've been having. So welcome so much on board. Here we are. Thank you so much for giving us this opportunity to to be with you, and thank you for even accepting to offer your knowledge with the audience and with us as well. And today we're here. We just want you to help us understand criminal law or criminal systems.
Thank you so much.
Yeah.
You're most welcome.
Yeah.
I am happy to lend my knowledge to the society and to the viewers.
All right. So maybe there's something I haven't mentioned about who Dedan is. Kindly reintroduce yourself.
I'm an advocate of the High Court of Kenya. My full name is Dedan Chege Mwangi. I practice as Mwangi Dedan Chege Advocates. We offer both civil and criminal litigation, and also we do conveyancing. So we have different departments in the law firm, but my passion and my bias is mostly on civil and criminal litigation.
We've always heard of a civil case and a criminal case, and maybe help us understand the difference between the two. What is criminal law and what is civil law?
So the major distinction between the two is that in criminal matters, there are matters prosecuted by the state. So if you have a complainant, you do not prosecute your own matter. You forward your grievances or your complaints to the police. That is either the DCI or the Kenya or the regular police. They will carry out their investigations. They will prepare their file, forward to the ODPP, that is the Office of the Director of Public Prosecutions. Then if that file relieves to the level of charges or of our offense that can be charged, what can be charged in court of, then you are charged with that offense. Now, in a civil matter or in the civil jurisdiction, it is between party to party. So if I have a complaint against you, I do not need to go to the police station. I just file my paperwork in court, and then you are summoned by court to defend yourself. So then it becomes a matter between party A and party B. But in criminal jurisdiction, it is between the state and an individual.
All right.
Yes.
There are types of criminal acts. Do we have different, or is it just under one umbrella?
No, we have different criminal acts.
Yeah.
Maybe we may have offenses against the state. You may have offenses against a person. You may have offenses that touches on property. For example, you may be charged of malicious destruction of property. You may be charged, for example, of an offense of assault. And the assault may have several limbs to it. Maybe assault. You may have assault occasioning actual harm. You may have grievous harm, which also falls as a part of the assault. You may have murder. You have robbery violence. We also have other offenses that, so those are offenses that are captured under the Penal Code. So the Penal Code is usually the major statute that guides in terms of prosecution and offenses that you can be charged of. You may have other offenses that are not captured under the penal code, or that may be prosecuted using other statutes. For example, the Economic Crimes Act, those ones fall under different statutes. You may have the Sexual Offences Act, that's also an act that also guides in the prosecution and handling of offenses to do with rape, defilement, sexual assault, indecent act. So that's basically the you have a wide range of offenses that fall within the purview of criminal law.
So let's narrow down to the assault now.
Yes.
You've mentioned several types within the assault.
Yes.
Things that we do. There are things we do without us knowing that we actually, making a mistake or committing a crime that will need us to, to be judged or
Yes.
to have to prove ourselves in the court of law. When we talk of assault, what are we supposed to know in regards to it?
So assault, and just to be as simple as the simplest manner that as I can, if I hit you, I slap you, that forms assault, forms the ingredients of assault. However, if I hit you using an item, probably a sharp object, and I cause maybe your skin to peel off, then that still is assault, but it's now classified under assault occasioning actual harm. Then you may have an incident where I have hit you and I've broken your tooth or I've broken your nose. Then that forms under assault, but again, it's more grievous, so it's referred to as grievous, occasioning grievous harm. Now, how that distinction comes about is through a form we call the P3 form. That's how it's generally called, but it's in the proper term is the medical report. Now, for you to be able to prove an offense of assault, there is one critical piece of evidence that must be available and must be produced in court, which is the medical report. That is what we call the P3 form. So now the P3 form is the one that classifies the various types of assaults. So that when the doctor is examining you, they'll indicate whether it's harm, it's grave, or it's grievous harm. And that is now what will influence the ODPP or the investigating officer on which charges to prefer under the general umbrella of assault. Yes.
All right. 22914 Facebook page Mwangaza TV and YouTube channel Mwangaza TV Kenya. When we're talking about assault, especially the sexual assault, there are times when someone will say, I only touched. Yes. The other one raped. The other one did something close to rape. How do we differentiate between the kind of sexual assault that has been inflicted on someone and maybe the impact of the same?
So now the major distinctive factor would be, for example, for you to be charged with rape, there must be evidence of penetration. And now we go deep in and say you have to mention whether it's you allow me to use those words because that's what we use in court, whether it's penetration of the vagina using the penis. So that forms an offense of rape, or probably penetration of the anus. That is when now you have you're talking of depending on the gender that's complaining of the offense. Now, when that happens, that becomes rape. But now you may have penetration using an object. So probably using, for example, a stick. If now that happens, then that does not amount to rape, it amounts to sexual assault. Now, where someone improperly touches you, or touches, if someone complains of being improperly touched, for example, your sexual organs are touched using probably the hands, then that becomes an indecent act. So now the Sexual Offences Act defines those offenses and gives the specific ingredients, and also gives the specific, prescribes the specific punishments when, depending on which act was committed. Again, we may have other limbs under the Sexual Offences Act. There's the introduction of now defilement. So when the Kenyan statute, the Kenyan law states that a person below the age of 18 years has no capacity to consent to sex.
Yes.
So in as much as the sex was consensual, and if you may, maybe just take you back, when for you to prove rape, it has to be penetration without consent or non-consensual penetration. Now, if you have non-consensual penetration or even consensual penetration with a minor, then that becomes defilement. So in as much, it doesn't matter whether the minor consented, as long as under the law they have no capacity to consent, then that becomes defilement. And there's a discussion around that issue, because if you have a 17-year-old and a 17-year-old, or and a 17-year-old boy and a 16-year-old girl, they are in high school, they are lovers, and they end up having consensual sex, then you end up jailing the boy, because the law requires the age of consensual to be 18 years. Then there are those issues that have been discussed, and most the Court of Appeal has directed actually the enforcement bodies, the Kenya Road Reports and the AG, to try and see if they could come up with regulations to properly structure that aspect of the sexual.
So that means, as per now, our boy is not covered under the law. He is not protected.
Yes, he is not, and he's not protected. And if you carry out research, you find out that in most of our prisons, we have young boys being condemned to 20 years, 15 years in prison just because they had consensual sex. And I just say this quote unquote, but the girl continues with her schooling and joins university and goes on with her life, and the boy continues to languish in prison. So there have been discussions that maybe we need to lower the age of consent to maybe 16. There are others who say that the court needs to look at the circumstances. Yes, there is a defense. If you look, depending on how you argue the case, if you did not know that this person was below the age of 18 years and they carried themselves as adults, you may have a reprieve. But in most cases, as long as someone is in school, they are presumed to be under the age of 18 years. So therefore, it's a very gray area that we, as in the legal fraternity, that we are calling for a lot of scrutiny, so that you don't end up punishing innocent. It's called, the term is Romeo and Juliet situation.
Yes.
We're lovers, and at times you even go to court and the girl says, I love this boy, I don't want him. But the law is the law. So those are the kind of challenges that we face.
In recent times, we've had statistics stating that more women are being raped in marriages. There are times when even men complain of being raped in marriages. Now, how do I prove that indeed I have been raped by my spouse? Because you've said for me to prove that I've been sexually assaulted, I need to bring the evidence now in the setup of marriage. How do I prove that?
Now, the fact that you got married is not consent in itself. So every single act has to constitute a single act of consent
within the marriage.
So every single act of every time you get together, as long as there is consent, that is okay. So if at one point you say no, probably in most of the cases would be the woman or the wife in the circumstances. If she says yes, that's okay. If she says no, then the husband has no option but to cannot force the wife into intercourse. Now, if in another instance intercourse has consented intercourse has commenced. And then at some point, the other party says no. Continuation of that act amounts to rape. Because now, initially there was consent, then along the way, the other party says no. So then from that point, then that becomes rape, because now it becomes non-consensual sex. So that is the logical explanation of it. However, it's very difficult, due to societal stigma and the way, a man and a woman in union, they are construed to be in the union for certain reasons. So it becomes very difficult for a woman now to complain of rape within the marriage. But as in terms of the law, that should be the case. Yes.
Help us understand some of the things the law or the court will look at, especially in pursuit of a rape case. Because we've had cases where someone has been raped, maybe we don't know what to do or what we need not to do before we can go to report our case. And by the time we are doing that, we are told there was no evidence to show that you are indeed raped.
In most offenses, there's always the issue of witnesses. If, for example, when we discussed assault, you may have been assaulted in the presence of other people. So then those other people form part of your evidence as witnesses. But as we all know, most of the sexual offenses happen between the complainant and the accused person. So therefore, the issues of witnesses, you may not have witnesses to corroborate that the fact that you are raped. So now, in this case, the evidence that would help you in proving an offense of rape would be the medical evidence. Now, medical evidence and other, for example, if you are raped and there is biologically maybe something was deposited in you, so then and that's why you're told the rape victims are advised not to take a shower or to change clothes, because the spermatozoa in your body, that forms part of evidence, that's DNA evidence. The clothes, torn clothes, maybe blood, that also forms part of evidence. And now immediately that incident happens, you are report to visit a medical facility where they prepare something called a PRC form. A PRC form is the post-rape care form. That forms part of it's a critical document in prosecution of rape offenses. Then we also mentioned about the P3 form, that is a medical report. Again, that also forms critical evidence in to prove that indeed the offense of rape occurred. Remember we said for you to be charged and be convicted of the offense of rape, there must be evidence of penetration. And that can only, in as much as you, the victim, you're saying, yes, person A or person B penetrated me, you need to corroborate that using evidence, and that can only be obtained through the medical examination and medical report. That now the doctors will come and testify and say, yes, from my examination, which was conducted within a few hours or within a few minutes after the act, I can confirm that the act happened. Now, for example, if you take an example of someone who visits a hospital after 1 week, and then the doctor says, yes, from my evidence, there is evidence of penetration. But you see, the difference between hours and the days that have passed, now that waters down the evidence. Yes.
So we shall be back, remember, with Advocate Dedan Chege, Advocate of the High Court of Kenya, and we are here just trying to understand the difference between the criminal and the civil justice system or the civil law. But basically we are talking about the Criminal Act, and he's actually helping us to understand more and more, so stay tuned. Welcome back on board. We are here trying to understand criminal justice system, and of course I'm with Dedan Chege, an advocate of the High Court of Kenya, who is helping us understand this. Before we took a break, we had actually tried to understand what is entailed as evidence, especially during assault, sexual assault, and defilement. As we continue in today's discussion, Mr. Dedan, help us understand or elaborate on why two people who've committed the same crime, have gone through the same system, get a different judgment or a different ruling altogether. We'll have one being sentenced for life and someone else is being given 12 or so years. What creates the difference?
So for most offenses, the law prescribes probably the maximum sentence.
Okay.
So maybe the law says, for example, if you're convicted of assault occasioning actual harm, that's a felony. So for example, the law may say, if you're found guilty or you're convicted of the same offense, then you are liable to imprisonment for a period not exceeding 5 years, or to a fine not exceeding maybe 1 million, or to both. Now, so the word not exceeding has a very major implication on the kind of sentence that is given or is rendered. Now, depending on different perpetrators, the circumstances of the offense, the commission of an offense might be so grievous such that the court has no option but to give or to render the most severe sentence.
The maximum.
The maximum. Or the commission of an offense must be so narrow that, yes, there's an offense, but it was not as grievous as would lead at the conclusion of a maximum sentence, or probably repeat offenders. For example, if you are a repeat offender, then you'll be sentenced more, or you risk suffering or suffering a higher sentence or a more stiffer sentence than someone who is a first offender. Then there is something called mitigation. Once you're convicted, the court says, I find you guilty of the offense of, for example, assault. Now, the court orders that a pre-sentencing report be prepared by the probation office. Now, that report might work in your favor. And as I said, if you are a first offender, or probably if you are remorseful, if you have reached out to the other party and they have forgiven you, then the pre-sentencing report might influence the court to give you a lesser sentence. Now, if in mitigation the court finds that you are a threat to the society, so the probation officer will go to the community, will interview the members of the community and find out if the community is interested in having this person back in society. So if the pre-sentence report does not work in your favor, then the court might sentence you to the maximum sentence. So it depends with the circumstances of the offense, the nature of the offense, and the nature of the accused person.
There are times we've seen petitions in court.
Yes.
Someone petitioning on behalf of his or her client, maybe to be given a bond, and there are times when some are given while others are not given. What are the factors that are considered when doing that?
So the bond policy is discretionary on the court, but the general principle or the general rule is that all offenses are bailable. And under the Constitution, there is the Bill of Rights that as much as you have been charged with an offense, under Article 50 of the Constitution, you are presumed to be innocent until proven guilty. So then, in that premises, as long as you have been charged, doesn't matter what offense, it doesn't matter whether it was rape or petty crime, stealing a pen or committing murder, all of you are presumed innocent until proven guilty. And so the general principle is that all offenses are bailable, and you have a right to bail unless there are compelling reasons that may cause you or may cause the court to deny you bail. For example, if you are a flight risk, maybe you stand a chance to maybe flee the jurisdiction or the country. Probably if you are a threat to the society, that probably you have committed the offense, you have committed murder, and the society is so mad at you that if the court releases you back to the society, then you start the risk of being lynched. So you may be denied bail, or if you stand a chance or the risk of interfering with the witnesses. And especially in murder cases, the court might direct that yes, you'll be released on bail, but after the witnesses, some witnesses have testified, some maybe vulnerable witnesses have testified. So what the court normally looks at is if there are compelling reasons that might, if we don't know where you live, we don't know whom you live with. And again, we go back to the probation office. We mentioned the pre-sentence report. There's another report called the pre-bail report. So the probation officer will prepare a pre-bail report that will guide the court on whether the person deserves bail or not, and even if they deserve bail, to what extent. Yes.
During the introduction, you mentioned that when we're talking about the criminal law, we are basically talking of crimes committed against the state. But then we've seen in recent times when the state is actually committing crimes against us, like the relationship between the citizens and the police forces has deteriorated of late. How do we go about it? Is it also the same law that is going to work on the same?
So the bottom line is no one is above the law.
Okay.
The only person who cannot be prosecuted of an offense when they are in office is the president. But once they leave office, they can be prosecuted. Now, in terms of police officers, in terms of maybe people in government, those are not, cannot be protected under the immunity rule. Now, if a police officer shoots an innocent bystander, that officer is not looked at in the eyes of, the blanket eyes of you are in the police force. That person is officer A, B, C, X, Y, Z. So they will face charges as officer X, Y, Z. Now, however, you have a situation where a police officer has shot or injured or killed a citizen, and then now you report this officer to his fellow officers.
Yes.
The chances are they might not be willing to prosecute him.
That's true.
They might not be willing to investigate their own. Now, in that case, in that incident, we have an institution called IPOA, or Independent Police Oversight Authority. Now, that is an independent constitutional body established under the Constitution of Kenya 2010 to help in such instances. And we have seen during the Gen Z protest, we had officers who were captured shooting peaceful demonstrators or peaceful protesters, and their names, in as much as the fellow police officers were not willing to investigate such cases, they were forwarded to IPOA, and IPOA carried out independent investigations, and you have seen people being arraigned in court. In as much as they are police officers, they have been arraigned in court through the help of IPOA. Yes.
So, for the sake of our viewers today, can we confirm that IPOA has the mandate to sue or to forward cases directly to the court for someone to be prosecuted?
Yes, IPOA has a mandate to carry out independent investigations and recommend to the ODPP for possible prosecution. The only body that can prosecute cases in the country is the Office of the Director of Public Prosecutions through the recommendation of the police, through the DCI or the regular police. But in the instances where you have police officers being the suspects or the accused persons or accused of committing specific crimes, then IPOA comes in, carries out independent investigations. They may direct the DCI to carry out further investigations, or they may, if there is conclusive evidence, forward that they are filed to the ODPP for possible prosecution.
Beautiful. So your final remarks as we wrap up our show today?
My final remarks would be that both to the complainant and to the victim and to the accused persons, if you are a complainant and you have a complaint against an individual, please go through the motions of the criminal justice system. Go to the nearest police station, make your report, get your OB entry, and follow up with the investigating officer or the OCS of that area. Go carry with you your witnesses or your evidence, and that will aid in the investigations, and ensure that if you have a strong case, ensure that that case is taken to the ODPP for prosecution. Now, if you are an accused person or you have been accused of having committed specific offenses, the law prescribes that you are innocent until you are proven guilty, and not just by anybody. If you are proven guilty, by a court of competent jurisdiction. So then, when that happens, you have a right to defend yourself. You have a right to challenge the evidence that the prosecution or the investigating officer has tabled against you, and that's why now we come in as lawyers, because you may not have the legal knowledge to understand the process and know how the specific elements of an offense and how to defend yourself. So that's why you hire advocates, because that is what we do. We have the knowledge and the experience to understand the different elements of an offense and how to assist you to buy back your freedom.
Are we supposed to give our evidence within the police stations?
You have a right to remain silent. If you feel it's necessary that the police officers knows your side of the story, you can do that. But you have a right to remain silent. And I always advise people, do not be quick to give your
side of the story.
The side of the story, or what you call record statements.
Yes.
Because that's what the police do. Once you're summoned or they arrest you, the first thing they do, they give you a piece of paper and tell you, now record your statement. And mind you're not the one who is writing. You just give your side of the story, and then they write. So you have a right to read what they have written before you sign, and you have a right to seek advice. There's the law, the Constitution, under Article 49 of rights of an arrested person. You have a right to call. You have a right to a phone call, so that you notify either your advocate or someone who can assist you, that notify that you have been arrested, and seek advice. Do not be so quick to record, because they tell you tuambie tu alafu
record statement
tutakuondolea mashtaka. Do not be quick to do that. Always make sure that you have sought advice and you are saying what you not incriminate yourself. Yes.
Thank you so much. Thank you so much for your time. May the Lord bless you and do you well. Maybe there's someone watching and he will want to know how or where you can be found. I give you that opportunity to please tell us.
Yes, as I said, my name is Dedan Chege. I practice in a law firm as a partner in a law firm called Mwangi Dedan Chege Advocates. We are located at the Ruiru Bypass, what's commonly known as Kamakis. We are reachable on phone. I don't know if I'm allowed to give my phone number. Then my phone number is 0723 956 997. 0723 956 997. If you reach out, we will be glad to assist you. Thank you so much, and God bless you.
God bless you too. Thank you. We've come to the end of our show today, Legally Speaking. In case you have a question, you have an observation, please reach out to us through 22914. You can also follow us on our Facebook page, Mwangaza TV, and our YouTube channel, Mwangaza TV Kenya. And just in case you've missed out on the other episodes that we covered in reference to different matters, do the same. Visit us on our YouTube channel. You are going to be educated and enlightened all the same. I'm your host, Celestine Waka the Favored. Till next time, same place, that is here in Mwangaza TV, every Monday, 7:30 p.m.